Good morning to all of you. I wish I could speak in Malayalam, but that's not possible. Please allow me to speak in English. I think there will be some translation will be done. The subject, gender equality and succession law, a very important issue. But then only thing is that after 75 years of our constitution, we are still discussing about gender equality and succession law. But before I begin my topic, I should start with an introduction that the people of India, more particularly the people of Kerala and Tamil Nadu should be congratulated for defeating the communal forces in the 2024 elections. 2024 election result has given a very significant result where the BJP party was made as a minority party in the parliament. You were all able to vote only 240 seats in the parliament. Thereby, Modi-Shah government has become a minority government, surviving only on the insulin provided by Naidu from Telangana, Andhra Pradesh, and also Nitish Kumar from Bihar. Now this election decisively showed that the people will choose parties which will go by certain democratic norms. No, I only mentioned about the elections.
Okay.
How the people voted and gave the Modi government only a minority status.
ലിംഗസമത്വത്തിനെ കുറിച്ചും സ്വത്തവകാശത്തിനെ കുറിച്ചുമുള്ള ഒരു ഇൻട്രൊഡക്ഷനാണ് ജസ്റ്റിസ് നമുക്ക് ഇപ്പോൾ തന്നത്. കഴിഞ്ഞ ലോക്സഭാ ഇലക്ഷനിൽ 240 സീറ്റ് മാത്രം ലഭിച്ച് മോദി സർക്കാർ അധികാരത്തിലേറി എന്നത് ഇന്ത്യയും കേരളത്തിലെയും തമിഴ്നാട്ടിലെയും ജനങ്ങളുടെ ഏറ്റവും വലിയ ഒരു ജനാധിപത്യത്തിലുള്ള അവരുടെ പ്രക്രിയയുടെ ഭാഗമായിട്ടാണ് ഇത്രയും കുറഞ്ഞ വോട്ടോടുകൂടി വീണ്ടും മോദി സർക്കാർ അധികാരത്തിലേറ്റത്.
How this decision is important is a very significant question. You know, during the election, Modi was going all around India and more particularly came to South where they don't have much votes. Their slogan was, Aapki baar, 400 baar. That is, we will get 400 seats. That is their slogan. In fact, very humorously, you know, in Madras, Chennai city, Modi came 7 times. One time he came, there was a road show. The road show, they kept taking him in an open jeep and somebody shouts slogans, Aapki baar. They expected it will be 400 baar. But then the Tamil people do not know much Hindi, and that bazaar they were going is having a lot of ice cream shop. So when somebody said, Aapki baar, the reply was, Chako bar. Not 400 bar, Chako bar. So finally Modi government got only Chako bar and not 400 bar.
ഈ ഒരു എത്ര സിഗ്നിഫിക്കൻ്റ് ആണ്, എത്ര ഇമ്പോർട്ടൻ്റ് ആണ് എന്നത് നമുക്ക് മനസ്സിലാക്കാം. ചെന്നൈയിൽ മോദി 7 തവണയാണ് ചെന്നൈയിൽ വന്നത്. തമിഴ്നാട്ടിലാണ് അത്രയധികം ഹിന്ദി അറിയില്ല എന്നതുകൊണ്ട് പോലും അബ്കി ബാർ 400 ബാർ എന്നതാണ് കഴിഞ്ഞ ഇലക്ഷന്റെ മുദ്രാവാക്യം. എന്നാൽ മോദി കഴിഞ്ഞ തവണ ചെന്നൈയിൽ വന്നപ്പോൾ അദ്ദേഹം പ്രതീക്ഷിച്ചത് അബ്കി ബാർ 400 ബാർ എന്ന് പറയുമെങ്കിലും അബ്കി ബാർ 400 ബാർ എന്നാണ്. അത്രയും പശുക്കൾ വരുമെന്ന ആ ഒരു രീതിയാണ് നമുക്ക് മനസ്സിലാക്കേണ്ടത്.
Before the election, the party was very confident that they'll get majority. Therefore, they were making many kind of statements. Many hidden agendas were there, which nobody knew. But one agenda, which they were very particular, which also found in their election manifesto, is the common civil code. They said, when we come to power, we will bring a common civil code. We do not know what really means common civil code, because before election, they used Uttarakhand government, which is their laboratory for this experiment. Uttarakhand government passed a law. You know, there are 4 holy places in Uttarakhand. They are called as Char Dham. Char Dham includes Kedarnath, Badrinath, Ganga Devi and Yamuna Devi. 2 are rivers, 2 are temples. All the 4 into one circuit. Millions of rupees are made from these 4 centers. Therefore, the Uttarakhand government passed a law called Controlling Religious Establishment of Char Dham. That is a law controlling the Char Dham, so that the money that is collected, the administration also maintained properly. When this law was made by the Uttarakhand government, that was challenged in the Uttarakhand High Court. Our Subramania Swamy from South, he always goes to all these controversial places. He also filed a petition that Hindu temple should not be controlled by the government. It should be left only to the Hindus and not by the government. This was their argument. Fortunately, the Chief Justice of Uttarakhand at that time was Ramesh Ranganathan from Andhra Pradesh. He was from Tamil Nadu. He was in Andhra Pradesh and he was one of the finest judge. He wrote a very long order, some 100-page order, rejecting the arguments of Subramania Swamy and the BJP, saying that at some point of time, you should have some control, because money that is collected is several crores of rupees and it can't be left to individuals, and therefore control is necessary. In that judgment, he asked 2 questions. Now, if Badrinath and Kedarnath are established by Hindus, is Ganga and Yamuna are also established by Hindus? They are rivers, they were in existence for time immemorial, and then just because you are showing some arti, it doesn't become Hindu property. So he asked this question, that why not government control these rivers which are being worshipped? And millions of yatris come for the Char Dham tour, and therefore he appealed the law. Then the matter went to Supreme Court. Supreme Court refused to grant a stay order. The law became enforceable law. What the BJP did was, they told the Chief Minister, if you do not withdraw this law, we will resign from the assembly. When that threat came from the BJP party, the law itself was withdrawn. A law which is to control a religious endowment is now withdrawn at the pressure of the BJP. Why I am saying this was, if you do not want to control Hindu places of worship, how is that you are making a law for Waqf control? The Waqf for Muslim endowments, religious endowments, there are already laws made by the state government and also by the central government. Now, if you want to bring a law, have more governmental control, now you will have to pass the law in the parliament. Now, with this minority, with 320 votes, you cannot pass this law. So, when the bill was introduced in the parliament, they could not pass, which they knew, and even Nitish Kumar was opposing. Naidu was showing reservation. So what they did was send it to the Joint Parliamentary Committee. Joint Parliamentary Committee going all over India, recording evidence. So far, the committee has received 1.2 crore petitions opposing the bill. Those who are supporting the bill, only 62,000. Now, not even 1% of the total people who are supporting this. Majority of the population have opposed the bill. Now the bill is only in the discussion stage. Why I am bringing the Waqf amendment was that if it is before the election, or if they got 400 bar, it would have been passed without discussion. Now there is a discussion all over India, and there is a debate whether the bill should be passed or not. And there are so much discussion, you may always expect the bill never be passed because the people are opposed to the bill itself. And that is the significance of our 2024 election result.
ഇത്തരത്തിലുള്ള ഒരു ഉത്തരാഖണ്ഡാണ് ഇത്തരത്തിലുള്ള മോദി ഗവൺമെന്റിന്റെ ജാതിന്മേലുള്ള പരീക്ഷണശാലയായിട്ടുള്ളത്. നമുക്ക് ചാർധാം ക്ഷേത്രത്തെക്കുറിച്ച് എടുക്കാം. ഉത്തരാഖണ്ഡിലെ ഏറ്റവും പ്രധാനപ്പെട്ട തീർത്ഥയാത്രാ കേന്ദ്രമാണ് ചാർധാം ക്ഷേത്രം. ഇതിൽ ഒരു ഹിന്ദു കൺട്രോളിംഗ് അതോറിറ്റിയാണ് ഉത്തരാഖണ്ഡ് ഗവൺമെൻറ് കൊണ്ടുവരാൻ നോക്കിയത്. ബദ്രിനാഥ്, കേദാർനാഥ് എന്നീ രണ്ട് അമ്പലങ്ങൾക്കൊപ്പം ഗംഗയ്ക്കും യമുനയ്ക്കും കൂടി അവിടെ അത്തരത്തിലുള്ള ഹിന്ദു ഗവൺമെൻറ്റിൻ്റെതായിട്ടുള്ള നിയന്ത്രണങ്ങളാണ് കൊണ്ടുവന്നിട്ടുള്ളത്. ആ സുബ്രഹ്മണ്യൻ സ്വാമിയുടെ ആ നിയമം ചലഞ്ച് ചെയ്തുകൊണ്ട് ഹൈക്കോർട്ടിൽ പോയിരുന്നു. എങ്ങനെയാണ് രണ്ട് അമ്പലങ്ങളെ നമുക്ക് കൺട്രോൾ ചെയ്യാം, പക്ഷേ എങ്കിൽ ഗംഗയും യമുനയും രണ്ട് നദികളാണ്, അതെങ്ങനെയാണ് ഹിന്ദുത്വയുടെ കീഴിൽ വരുന്നത് എന്നാണ് സുപ്രീം കോടതി ആ നിയമത്തെ ഉത്തരാഖണ്ഡ് ഹൈക്കോടതി തന്നെ ആ നിയമത്തോട് പ്രതികരിച്ചത്. ഈ രണ്ട് ചോദ്യങ്ങളാണ് സുപ്രീം കോടതിയിൽ ചലഞ്ച് ചെയ്ത് വന്നത്. ഈ നിയമം പിന്നീട് BJP ഗവൺമെന്റിന്റെ പ്രഷർ മൂലം പിൻവലിക്കുകയായിരുന്നു.
Okay. Finish and then at the end you can make. Sorry, there is small confusion, but then one thing you must know, in Uttarakhand and in Uttar Pradesh, it's a BJP-controlled government. This year, during September, there is a festival in North India where the states around Delhi, Haryana, Rajasthan, Uttar Pradesh, Bihar, some portion of Bihar, people used to walk with a small kavadi, in Tamil it's called kavadi, small, they'll walk all the way to Haridwar, where there is a Ganges, and they'll fetch water from the Ganges and then take it to their village for celebrating in the Shiva temple. This festival is called Kanwar Yatra. Kanwar Yatra means the people will go up to Ganges, bring water to their village and walk 200-300 kilometers. And this year there were 4 crore people were walking this Yatra, Kanwar festival. Now during this festival, when the Yatris are going, there will be a lot of food stalls, there will be water booths, there will be convenience, public restrooms will be built for this sake of the Yatris. Now, put it this way. Now for the sake of the Yatris, they will arrange food stalls. Now this time, the two government passed an order, very significant order. Those who are running food stall must put their name of the owner prominently in a notice board. Suddenly this yatra has been going on for several centuries. Now suddenly two governments are coming with a circular, with an order that you should exhibit the name of the owner. You will all know what is the reason for this ownership business. When the Yatris come, they will read the board. No, this is not our man. We will go to some Hindu shop. This was the why this circular was made. That is, make the commerce into a communal divide. A Yatri doesn't mind whether he eats in a Muslim shop or in a Hindu shop. But the government wants to divide the Yatris on the basis of religion. Therefore, they passed a law that every shop must have the owner name prominently exhibited. Otherwise, they will be prosecuted. When this was brought to the notice of the Supreme Court granted a stay, saying that why do you want to make this kind of a new arrangement? Nobody has ever even asked who is the owner. They want to eat, they eat any shop they want. Now, this is something which the BJP experiments in the state where they are running. The commerce is used to divide on a communal line. And this is a very important issue. We should thank that the Supreme Court was able to grant stay on these orders passed by the two governments. And the festival went off. There is no obstruction or anything like that. Like many years, the festival went off very smoothly. But one thing we must know, when we talk about gender equality, what is gender equality? There is no doubt on whether the gender should be equal or not. There is one gender is less equal and one gender is more equal is not our theme. In this context, you will know, in the United States of America, there were 13 colonies of the Britain. In 1776, the colonies got independence, not by British government. They fought a war and got their independence from the British. The 13 colonies formed a federation and made a declaration, the Declaration of Independence of the United States of America. Now, when they made this declaration, the first sentence said, all men are born equal. In 1776, the American Day of Declaration of Independence said, all men are born equal. What about women? It was silent. Now, what about the blacks? It did not mention about black. In 1820, the slavery was abolished and it declared no person should be held as a slave. All men are born equal should have a meaning, and therefore slavery was abolished. The blacks were started being treated equal, and then still the women are not treated equal. In 1920, a century afterwards, after the abolition of slavery, the women got voting rights. For the first time in America, the American women went to the polls and voted for their candidate. 1920. Therefore, if you see, all men are born equal was there in 1776. But today, if you see the America, it is not only the men, the women are equal. It is not only the whites, it is also blacks are equal. That is why you will find Obama getting elected 2 times as the president of the America. Now the words, it may contain the same words, but then the meaning that is given to the words is changes according to the society. Society doesn't lie stagnant. Society doesn't lie dormant. Society keep on changing. The same words after 200 years has got a new meaning where all men are equal has become all are equal, and there is no distinction whether gender or whether race. That lesson from America we should apply to our country, and therefore you should understand there is no doubt whether there should be a gender equality or not. When the Constitution was enacted, there are enough provisions in the Constitution. You will find in 1950 when we adopted the Constitution, it made very significant change. Article 14, everyone is equal and there is an equal protection of law. This is an equality clause. The preamble of the Constitution says all are equal, justice, liberty, equality and fraternity. And then Article 15 says the state shall not discriminate on the ground of sex or religion or language or descent or any one of them. And therefore, when 15 says that the state shall not discriminate women on any ground, there is a declaration by the state, I will not treat women differently only because they are women. That's a very important issue. Similarly, Article 16 talks about in any public employment, there cannot be discrimination based on women. That you are a woman, therefore you are disqualified. That's not possible. I remember in 1964, there was a case in Kerala. That case is, that girl's name is Rajammal. She filed an application to get into the last government service, the peon post, attender post in the government service. She was rejected. He was not selected because the rule said that you should know cycling. You know, last gate servants like peons and attenders are used by officers for so many views, going to the market, going to the theatre, going to bus stop, taking the children to the school. Therefore, when the men is employed, they will do the work. Women will not do the work, therefore no women. Now this is something unwritten rule. When the Kerala High Court found this rule is totally illegal, that you are trying to edge out women for non-stated reasons. Therefore, if you say cycling, women will also know they can learn cycling. It's not a difficult thing. Your intention is used to women for some other work other than the office work. Therefore, we will not allow this discrimination. Rajammal was a state of Kerala, one of the landmark cases where for the first time the Kerala High Court said we will not treat women in the light of Article 16. Article 16 says the state shall not discriminate against any person only on the ground of sex, language, religion, or descent, or any one of them. And therefore, we found for the first time the meaning of the Constitution being reenacted by the Judicial Forum, and Rajamal case even today remains as a very important case. Now the question is not just to become peon or a clerk or a collector. Question is becoming a judge. Today most of the courts are run by only men. The Supreme Court we have only one, or now there is a second woman being appointed. In the High Court we have only 2-3 women, never the percentage equivalent to the women. Today women are equal to men in respect of population, in respect of voting strength, but still for the last 20 years we are still discussing whether seats should be reserved in the assembly and in the parliament. 33 and 1/3%, that is 1/3 seat should be given to the women. There is no difficulty at all because they represent so many people. Now we talk about diversity, we talk about plural nature of this system. Then why we are not able to pass a law providing a reservation for women in the parliament? Now Modi says last week, we are counting the population, we are taking the statistics, we will reserve in 2029. That means he is reserving even for next election to vote for him. Why can't you do it today? If you see the electoral rolls, 48% are women voters. Then what other statistics you want? That even for a simple thing, like having share in the parliament, they are not willing to give it to women. Because it's entirely a male-dominated world, it is difficult for the male to give up their brief. Even our Chief Justice of India last week said that in order to have diversity in the High Court and Supreme Court, we should recruit more women judges. Why should there be women judges? Some showpiece? They also knew when the women adorn the benches of the court, their look, their approach, their decision-making process will be totally difficult. Totally it will be different. It will have a very female approach to the problem. I am not saying for theoretical reasons. 2 years back, in the Jindal Law University, which is in Haryana, one of the very expensive university, in that law school, there was a seminar, there was a workshop. What is the workshop? Feminist judgment writing. That is, if a judgment is written by a female, whether it makes a difference or not. So they gave 10 judgments to us. You write differently, it's possible. So out of 10, the judgments written by women are totally different from the judgments already pronounced by men. What does it show? If a woman sit in the bench, the approach to the problem can be definitely different because 10 out of 10, the decision was different. This is only a theoretical exercise, knowing that the Chief Justice of India says we should have more women on the bench in order to have diversity. If the Supreme Court should have diversity to have a proper judgment, then we should understand there is something important about gender equality. Now, gender equality, even Supreme Court Chief Justice praised Kerala. 72% of the women are now judges in the courts below the High Court. Not in the High Court, but in the below the High Court. By writing competitive exam, by going through the interview, they were able to become civil judge junior division, then civil judge senior division, then district judge. Thereafter they may be promoted. But today the so-called subordinate judiciary, there is 72% women in Kerala. It shows a trend. Chief Justice said, we are proud that Kerala is able to achieve a new situation where the judiciary itself is get transformed. The transformation is more important because a man looking into the problem is not the same as women looking into the problem. It's just not mere the question of approach. Even today's usage, today the words used in the courts, there can be different meaning can be there. I can give a small example. There was a district judge in Gwalior, Madhya Pradesh. She was one of the good judge. Every district we have a High Court judge in charge of the district called portfolio judge. He is like a minister of the district. So the portfolio judge by a man called Ganguly, not the old Ganguly, this is Ganguly. he was having his birthday. So all the judges will go to his house and then give their bouquet or shawl or whatever it is. When this girl, this additional judge, Gwalior, went to his house, gave a bouquet, then this judge told her, "You look very beautiful. Please perform a dance for me." So she got very annoyed because she was a district judge. She was in charge of the whole district. And here is a High Court judge who is telling her, "You have a dance." What kind of a thing? Do you think women are some entertainment piece? And she refused to dance. And she said goodbye and went home, only to receive a transfer order transferring her to 1,000 kilometers away. All this happens in the judiciary, you must know. Now, 1,000 kilometers away with a daughter who is doing +2 course in the final stage, 1,000 kilometers away means it will disturb her education. So she made a petition to the High Court, "Please keep the transfer away, I will continue to work." No, they said nothing doing, go. She went to the Supreme Court. The only good thing she did was she engaged a very brilliant lawyer, Mrs. Indra Jaising, one of the brilliant firebrand lawyer, senior advocate. She appeared for this district judge. When the case was being heard by the Chief Justice of India, Justice Kehar, there was an altercation in the court. The High Court was represented by a senior lawyer and Indra Jaising representing the district judge. When she was arguing, she made some point on how she has been victimized. The High Court lawyer, when she was arguing, he was giving a lot of false statement, which every time when he made a statement which is not factually correct, Indra Jaising interfered, saying that what he is saying is not correct, you should stand corrected. When there is a constant interference, normally what we are sitting in judge, we used to tell them, you have your turn and your turn will come, then you don't interfere. This is what the judge told Indra Jaising. Nothing wrong. Indra Jaising came and sat his seat. Now, the High Court lawyer, the senior lawyer, told the judge, "My lord, don't interfere, her speech is very delightful. Her constant interference is very delightful." This is something which nobody could even tolerate. It's not a very ordinary statement. Indra Jaising made a very fiery opposition. She asked that question, "Am I here to perform some dance performance? I am arguing my case, and then you say delightful. When a woman argues, is it all delightful? Are we coming to court only to perform some performance here?" Then the Chief Justice got flabbergasted. He originally thought some delightful is a very ordinary word. Then he writes in his judgment, which we can all read in the judgment, para 17, he begins by saying, "Every day is a learning process for us in court." A Chief Justice of India, which is the highest court in India, writes a judgment that every day is a learning process for us. In today's court proceedings, we were able to understand one thing, that the words do carry some additional meaning. We used to deconstruct the word and find out what is really there. Is it misogynous? Is it a man's world that a man uses his own word? Or we should understand, we should use different terminology, different words, so that there is no gender discrimination. Even in the matter of using English words, there is discrimination. There is a male-oriented words, misogynous words. And therefore, the judge said, for the first time we learned that even using words in court, there are sex discrimination. And this was there in the judgment. This judgment came some 10 years back. But fortunately, our Chief Justice of India, Chandrachud, has now released a booklet containing 60 words where they are all male words. It should be used as a gender-free words. You don't say any word which has got a male orientation. It should be a gender orientation. Now, Supreme Court has issued a guidebook how judges, when they are writing words, they should use consciously words which do not express any bias against women. This is something very important. We are also slowly growing. When I began by saying, after 75 years we are discussing gender equality, Supreme Court itself after 75 years issued a guidebook, which word should be used, which word should be avoided. This is something which is very important, the way in which we are going into a new area of controversy. It is in that sense, usage of words can also exhibit gender bias. It is in that sense I mentioned the Gwalior judgment, and when it comes to discrimination, one of the topics that we are discussing is a marriage. Marriage, first question is whether marriage is connected with the religion or not. If two people get married, they make a new living as a husband and wife, as a family. Maybe every religion says that family as an institution should be protected. That's a different issue. But then, what is the scope that the religion plays into this? There was a time when the British came here, each people who belong to different religion, they had their own customary practice. You must understand, custom does not mean religion. Custom is over a period you form certain customary practice, and therefore, when the British came, they found certain things which are not very shocking to the Western world. For example, when the husband dies, the woman is also put along with her, along with the same fire. She also goes along with the husband in the same fire. They are called Sati. Now there are so many temples for Sati Matas in Rajasthan. Now for the first time, the British in 1820 abolished Sati. Sati abolition regulation was passed. Warren Hastings period, Governor General of British Empire, he passed a law. It did not stop with Sati abolition, that a woman, the argument was, woman is so attached to the husband, when the husband goes, she doesn't want to live, and therefore she wants to go. That's one issue. Secondly, if a woman loses her husband, she becomes a widow. So widow has got strict procedural requirement. She has to shave her head. She should not be seen in public. Whenever she considered in any public place, it is considered inauspicious. Then what is the food that he should eat? I have written in one of my judgment, quoting a Marathi novel, where a widow is given the food which is left over by the dogs. That means she is so renounced from this world, she has to be cut off. Now during the British period, the people who were fighting for the Indian independence also thought of social reforms. They also said widow marriage must be allowed. Their children were get married. A girl of 13 years old, a girl of 9-year-old getting married. And then by the time her husband dies for some reason, she becomes a child widow forever. And therefore there was a strong campaign that this child should not be punished because of the parents' decision. There was a Child Marriage Abolition Act. There was also widow remarriage validated. Now widows can get married. This was something, a social reform, which has got nothing to do with any religion. A woman treated as a woman treated as a human being. Sati abolished, widow remarriage, and then the child marriage abolished. All that came as a part of a reform package. Nobody objected. Even nobody went to court. Even if they go to court, it will be upheld. Now, slowly, a society gets transformed into a better society. Nobody ever said, this Sati abolition, no, it interferes with our religious belief. Can you kill so many women in one day? It's not only for North. Even in our Tamil Nadu, the Raja of Ramnath, he died in 1920. Along with him, 24 of his wives were killed. As Sati, they went along with him. Now the question of Sati being worshipped, it also came to notice in 1987, there were so many temples for Sati Matas. Now there is a parliament passed a law that Sati in any form, worship is also a crime in this society. That you kill a woman and then worship her. This is not acceptable standard for our own society, and therefore Sati Abolition Act was there. Now Sati being worshipped has also been abolished. Therefore the society keeps growing. It grows in different way, but then there is a growth. People who oppose this kind of a change, they are either the people of old order or people who do not want any change in this society. Because they are not the sufferer. A man is not the sufferer if the woman is burnt alive. A man is not the sufferer if there is a child widow. And therefore, this is something which is very important. The question of a widow or a woman getting a right to property, this became another issue, because one of the issues we are discussing is the succession law. Can a woman inherit the property of her father and mother? Now, this is a question which is there not only today, even 100 years old, these questions have been agitated. Therefore, slowly, the parliament, the lawmaking bodies started thinking that women should inherit property in the same way as a men. There is nothing like women getting no property and men getting all the property. This is something which has got no basis or no religious basis. It is in that sense, slowly, the right for women to inherit property, the right for widow to inherit the property of the husband and also the father. These are all started coming. In fact, the British was playing a very mischievous game. A widow who doesn't have a child, but she wants to succeed to the husband's estate. If she does not succeed to the estate, she will not get anything. So they will appoint a minor, she will adopt as a son. If she adopts as a son, then the property will go to the son. She has to make an application to the British collector. Please recognize him as me as a guardian and the child to get the property. The British used to say, I will not give permission, which means the whole property will come to the government. So the British are also playing the same game of women does not get any right. The right to adoption by a Hindu woman was denied on her own choice. She has to get permission from the government. All this was slowly changing. You will all be very surprised. In the Travancore-Cochin Succession Act, the Syrian Christian, a married woman, she doesn't get property. They say you are being given enough dowry, and that is enough. Only the male brothers will divide all the property. What about the woman? You are married. You have given money when the time of marriage, so you don't get anything. Mary Roy, a school teacher, who is the mother of Arundhati Roy, she filed a case in Kerala High Court, which came to Supreme Court, saying that the this Travancore-Cochin Succession Act, denying the married woman the same right of as a man, is illegal. The Supreme Court fortunately held in favor of Mary Roy. The Travancore-Cochin Succession Act, denying married women equal share in the property, was erroneous, unconstitutional. Today you will find, after the Constitution was enacted, every law which stood before the Constitution must stand the scrutiny of the Constitution, must stand the test of fundamental right, and the court will decide whether the pre-constitutional laws are valid or not. It is in that sense, Travancore-Cochin Succession Act was held to be invalid. It is something very important. Similar thing happened in Kerala, where the Christian women, when they want to get divorced, it is not enough he is cruel, it is not enough he has deserted her. All that is not enough. You will have to prove the husband was also indulging with another woman. Adultery must be proved. So the double ground, single ground is not enough. You must have two grounds. Now that was challenged. And the Kerala High Court said, why should one ground is not enough? If he is cruel, then why should prove that he was living with another woman? So each ground is an independent ground. The the Divorce Act was challenged successfully before the Kerala Full Bench. Kerala Full Bench held that if a woman wants to have a divorce, it is enough she puts one ground, not two grounds. It is not a compulsory thing. And every time when you get a divorce from the district court, the High Court will have to confirm by 3 judges. This was the British law. Now that was held to be bad by the Kerala High Court, and that law has now been removed. Parliament has amended it. Therefore, we are making slow progress, not a very advanced progress. The progress through courts comes very late. But the vision, but the consciousness, but the awareness comes from the society. If there is no demand from the society, which court is going to examine this law is bad, that law is bad? I know my friend of mine who was an English author. She got a prize from London. Her name is Geeta Hariharan. Recently her book was also been released. One of her latest novel in Malayalam, it was translated. She got a prize in London for an English book written by her. Now that was 2,000 pounds. 2,000 pounds is something like our 2 lakh rupees now today. Now when the money came to India, she wanted to give it to her sons, 2 minor sons. So she approached the Reserve Bank, because it's a foreign fund. She approached the Reserve Bank. I want to give this money to my 2 sons, appoint me as a guardian and create an account. I'll put that in a fixed account. The Reserve Bank said, since you are a Hindu woman, you want to create a trust in favor of minor son, you must get your husband's signature. Now she got furious. She is an author. Her novel gets a prize. It is her money, but she is not unable to give it to her son unless the husband gives the support. So she asked, what should be done? We went to Supreme Court, challenging Section 6 of the Hindu Succession Act, which says, normally the father is a guardian. Normally the father is a natural guardian, which means father is a guardian and mother will become only when father is not there. Now when this was put before the Supreme Court said the word normally does not mean all time to come. There are situations where you can find abnormal situation where mother can be appointed. In fact, one of the case which I heard in 2009, a Muslim woman, the husband was a wayfarer, he was not taking interest of the child. She applied for a guardianship. The husband said, no, father is a natural guardian. We said, that is not the international standard. The international law today is, what is the best interest of the child? It is not father, it is not mother. Sometimes we can, for grandmother, we can give the child custody because the interest of the child is the paramount consideration all over the world. It's not only India. Therefore, in the Reserve Bank case, Geeta Hariharan won her case saying she is entitled to create a trust of her own in favor of the minor son. Unless somebody goes to court and then say there is a problem, this law is slightly against the women. This law doesn't teach about gender equality. Therefore, Geeta Hariharan succeeded. Mary Rai succeeded. And what does it show? That today our constitution do not recognize any gender inequality. It only talks about gender equality. The courts are aware of the situation. The law is very clear. The constitution is very firm. And therefore, we need not think twice on the issue of gender equality. There is another angle to this. When we are talking about gender equality and equal right in terms of succession, there is another method to say, since you are talking about marriage, now if there is a marriage between the same community, no problem. Between 2 different religions, what happens? There is no problem, you can register under some other special marriage act. If the law, the particular religious law do not provide. Suppose adoption. Suppose you want to adopt a child. Normally they said only Hindu law provides, no other law provides. Now how does the Hindu law get changed? How does the Hindu law really made enacted? When the British came, they were following only the customary right. They did not have a codified law for the Hindus. It was only during 1947, after the independence, Dr. Ambedkar being the law minister, created a Hindu code. That is, all aspect of Hindu women is made into a code. Marriage, succession, adoption, guardian, everything has been dealt in the Hindu code. When this bill, which was brought in 1947, at that time constitution was still being discussed. For 3 years, it came before the parliament. Discussion went on the Hindu code, whether we should have. Congress party, as you all know, does not believe in change all the time. They were only fighting for political independence. In terms of social reform, there were also conservatives in the Congress party. There were also progressives, like Pandit Jawaharlal Nehru is a very progressive. But even Pandit Nehru could not support Ambedkar because a whole lot of Congress party said, don't touch our religion. We will not support this. 28 speakers who spoke on the Hindu code in 1948 opposed the bill. All the 28 belonged to Congress party. So Congress party wanted political power, not a social change. But there were also some people who wanted to have a social change, want the society to change. It is not enough the British are replaced by Indians. It is also important that we are living in an egalitarian society where men and women are treated equal. Therefore, Ambedkar got so frustrated, he wrote a letter to Nehru. I thought you will support my view in amending this, bringing a comprehensive bill. Now you are just keeping silent. By the time Constitution came, new parliament elections were announced. So in 1951, Ambedkar effort to bring a common Hindu code completely lost. 3 years he fought for the change. After independence, after the Constitution came, in the fresh elections held in 1952, Ambedkar was defeated. He did not get elected. When he finally, they could not avoid him, so he got elected from West Bengal to the Rajya Sabha, and he was made again a minister. So he started his new effort. In 1955, he brought the same subject. Once again, the Hindu marriage amendment was not given consent by Dr. Rajendra Prasad, who was the President of India, who was the leader of the Congress party. They did not give. Therefore, you find whenever any change in law, there is always a resistance. People who already have power, people who already enjoyed power, they never want to give up. And therefore, the legal means also takes its own tortuous course. It's not just easy that somebody says you pass the bill. It's not so easy. And therefore, Ambedkar brought this bill. In 1955, when the bill was sent to the President of India, Rajendra Prasad, he refused to give assent. And a lot of discussion within the Congress party. In 1956, the bill was approved. The other 4 laws came as a piecemeal law, not as a code. Now, why I am saying this was, in the majority community, if there is no uniformity, if there is no consensus, it takes a tortuous path. It also says that you can't bring one common code. How is that the BJP party today talking about common civil code? If for one religion, you can't bring a common code, because there are so many conservative people out there. There are people who do not want change, people who oppose any kind of change, and in order to console all of them, you keep quiet. Now suddenly you talk about common civil code, therefore your bona fide become questionable. That why is that you are now suddenly talking about common civil code? That common civil code, does it mean uniform civil code? There is a difference. Our constitution talks about uniform civil code and not common civil code. Uniform means there are 10 schools in Kochi. There are everybody is wearing uniform, but it's not the same color. It can be blue, it can be red, it can be green, it can be any color. But there is a uniform doesn't mean common. But what is now being assessed is, you take the Hindu law, apply it to the Muslim also. Therefore, that's enough. That's a common. This is a very simple way of understanding, which we will not allow, because it is for the people to decide what the law they want. If the people doesn't want a particular law, we will also not force them to accept. It is not a majoritarian understanding of law. It is not the majority which decides what should be the law. It is also the constitution has to be satisfied as to which law that you are bringing. And therefore, when today we are talking about law, as told in the beginning, what is that we are demanding? There should be a marriage law, correct? Marriage law, should it have that the men can have any number of husbands and women will have only one husband? Is that the marriage law? Is there not equality on this? Now, first understanding is, what is the law applicable to man should be the law applicable to women. This is the first issue. When there was no polygamy allowed in the Hindu law, it was allowed. There were many legal provisions. What should be the money, what should be the succession of the second wife children or third wife children, all that could be different. For example, if you take in Punjab, all the boys don't share the land. It goes to the eldest son only. Because the estates are so big, they don't want to split the estate. And therefore, even today in Punjab, it is the first son who gets the entire control of the land. If you want, you cannot divide the land in between the sons. They don't want the land should be shrink into smaller pieces. We have different laws all over India. You may even consolidate all these laws. But most important today, the first principle is what is good for the man should also be the good for the woman. What is sauce for the goose is also sauce for the gandals. And it is in that sense, when we talk about marriage, we also talk about that polygamy is not the rule, it's a monogamy is the rule. Whoever it is, that should be the rule. And therefore, we do not think that would amount to interfering with the religion. This is first principle that we accept. The second principle is the succession. If there is a property, how that property should go, it should be devolved. Should the women be excluded, or the women should not get a right? It is in that sense we completely feel that the women should have an equal right in terms of property. When Mary Roy did not file the case, even today you will be governed, the Syrian Christian would be governed, where the married woman will get nothing. When the Supreme Court passed the law, there were several letters to the papers saying, at the time of marriage we spend so much money, how they can get a share. These are all the pedestrian argument that was advanced. Even when Kരണമ passed a law in Tamil Nadu in 1988, in the joint family property, women also will get a share. Previously, only the men will get their share. Today in Tamil Nadu, thanks to the state amendment, now it has become a central amendment also. In 1988, in Andhra Pradesh and in Tamil Nadu, a state amendment came which said the women will get the same right as that of the men. If that is good for one section, that's good for all section also. Why the property should be linked with religion? I have a property, I should divide my property. And why should you say men will get something more and women will not get? This was the position even in the Hindu law. That got changed. Not because of somebody liking for it, not because somebody had a meeting and passed a resolution. The overwhelming support of the women during the independence movement also supported not only the independence but also a social reform, that women are treated as women are treated not less than women, and therefore there was a change. It is that women, it is that overwhelming women stand that came for consideration during the period. It is the same thing that we are now demanding, that the law should be the same, which means men and women are equally treated. And I can always recall, unlike the American Constitution, which said all men are born equal, 1776, but it is not equal. Women were not equal, blacks are not equal. Whereas in our Constitution, in 1950, we said men and women are equal. And not stopping with that, Article 15 says, the state shall not discriminate based on sex, language, religion, or area, or descent, or anything for any one of them. There was a Hindi film by name Article 15. You will be very surprised that a Hindi film is having a constitution name, Article 15. The director was asked, why you are naming Article 15? There are 397 articles in the Constitution. Why you chose 15? The director said in the interview that Article 15 is the heart of the Constitution, because for the first time state says I will not discriminate. Previously there was discrimination. Previously when there were royalties, when there was British rule, when there were other rules by various other rulers, there was discrimination. Today for the first time, the Indian state told the people that they will not get any discrimination. And therefore the director said, in my film, I will give Article 15. Article 15 you should read again. We were there even before, 20 centuries before, we never had such an assurance. We had so many interpretations that men are more equal than the women. The women are less equal than the men. We had so many understanding that the women should be obedient to the men. All these misogynist, all these male-oriented positions were given away when our Constitution was written. It did not stop only with that. In fact, in Article 24, it prohibits trafficking of women. In the Part 4 of the Constitution, he talks about maternity relief, he talks about living wages, he talks about recreational rights for women. He talks about, Article 39 talks about that the resources of this country cannot be monopolized by a few, it should be decentralized. So we have a socialist charter in our constitution which has truly evolved over the period, and today, after 75 years, we are now raising our voice that there shall not be discrimination on the ground of sex. There shall not be discrimination that women being only women, they are being ill-treated or treated as a second citizen. Today, in the matter of marriage, in the matter of divorce, in the matter of succession, there must be a complete equality, and that is why this conference is convened to re-emphasize the same demand. It doesn't mean these demands are raised for the first time. These demands are available in public field. We are only focusing more on that. Our voice will be heard. Our voice will be heard by the lawmakers, and the lawmakers, we will make them to make the law which will be more just, humane and civilized. And for that purpose, I wish this seminar a success, and thank you.